The state of Washington is appealing a trial court's decision to grant Randy Coy Henderson a new trial following his first-degree aggravated murder conviction almost 2 decades ago. The new trial was granted after Henderson presented new testimony from a witness, which the court found justified a retrial as it passed the Williams factor test for newly discovered evidence. In 1995, John Robinette was found severely beaten in his apartment and later died from head injuries caused by a nail-studded board. Randy Henderson was arrested the next day and charged with first-degree aggravated murder. 2 others, Jimmy Pyles and Geoffrye Foutch, were also arrested and later pled guilty to first-degree murder. Henderson's trial included testimony about his incriminating statements and his involvement in planning the crime, but there was no physical evidence or eyewitness testimony directly linking him to the murder. Neither Pyles nor Foutch testified. Henderson was convicted by the jury and sentenced to life without parole. In 2021, Henderson filed a motion for a new trial based on new evidence from Foutch. He testified in 2022 that Henderson was not involved in the crime. Foutch, who had a history of conflict with Robinette, explained that he and Pyles planned the attack due to past essay by Robinette. Foutch said Henderson helped force open the door, but left before the assault and did not participate in the killing. He admitted to falsely implicating Henderson in 1995 out of anger. The trial court found Foutch's new testimony credible and consistent with earlier police reports, granted Henderson's motion, and ordered a new trial. The state has appealed the court's decision to grant that trial, arguing abuse of discretion and challenging the Williams factor test results. Let's take a look at the arguments.
Good morning, Your Honors. May it please the court, Jake Lervold on behalf of the appellant in this matter, the state of Washington. There's really kind of 2 issues on whether the judge abused their discretion, with the second issue being broken down into 2 different categories. So the first one, whether the court abused its discretion in finding that the testimony, or that Mr. Foutch's testimony was reliable, his recanting testimony, and second being whether the 5 William factors were found and the court abused its discretion on that. So first I want to talk about that second issue dealing with the Williams factors. So the first Williams factor, the state's arguing that the court abused its discretion based on untenable grounds by finding that it would probably change the outcome of the trial. The trial court did not go through an accomplice liability analysis in determining that, in granting the new trial. And the reason for that, and the reason that the court abused its discretion, is because the court seemed to put a lot of emphasis on the fact that he said that he didn't go inside. But there were numerous witnesses in the first trial that placed Henderson with Foutch grabbing bars, grabbing sticks, grabbing weightlifting equipment, testing the stuff out. There was a statement by Charlotte Hoyt that Mr. Pyles, one of the other co-defendants, said with Mr. Henderson about 10 feet away that, his intention to, or that he wanted to kill Robinette. And then Mr. Foutch himself even testified at the hearing back in 2022 that he helped push the door open. He said that he didn't know what the plan was. He went in, that he just stayed at the door, that he thinks he never went inside. And here, underneath accomplice liability, we know that Henderson was involved in the plans because we have Mr. Henderson's statement to Josephine where she asked, "Were you involved?" And he said, "Yeah." There's statements by Mr. Henderson in the record that he told a law enforcement officer, "I might have done it." There's other statements in the record that Pyles and Foutch both said to Josephine that Henderson beat him over the head with the 2x4. So to find that this would probably change the outcome of the trial, the court did not take into account the fact that Henderson went to Robinette's house knowing what was going on. He was helping to grab weapons. He was testing the weapons out. He was brought into the plans by Mr. Pyles. He was not brought into the plan by Foutch. So for Foutch to say he didn't know what was going on, Pyles himself, there's an eyewitness stating that they wanted to kill him, that that's what they wanted to do. And then he helps push the door open, grab weapons. The court abused its discretion because it didn't look at this from the accomplice liability aspect. The state's theory of the...
So, obviously, as you mentioned, abuse of discretion is our standard review. Everything you say suggests that, yes, that a jury on retrial could, in fact, find him guilty of accomplice liability, based on accomplice liability theory. But the question, isn't the question somewhat different it's not just could he be found liable. The question is, would this testimony probably change the result? And how do we second guess the trial judge who actually hears the testimony and weighs all the evidence?
And, Your Honor, the situation here is that the court never went through and actually looked at it from the accomplice liability perspective.
Well, hold on a second. Was the theory at trial that he was an accomplice, or that he was the principal?
So the theory at the trial, that you can see in the WIPIC that was cited in the state's brief, that the state argued accomplice liability, that there was this theme around the trial that they were conspirators together, right? There were statements in the...
What is that cite to the WIPIC?
It was WIPIC 10.51. It's page 21 of the state's brief.
What's the record cite?
The record cite, I do not have that with me.
Is it to the CPs, because those aren't in our record? That from his direct appeal, I believe there's a cite to the CP from Henderson's direct appeal that you cite to, but that's not in our record here. The RPs are. The report of proceedings.
Yeah, it was in the report of the proceedings.
Okay, so thank you. I'm going to check, but that's an important fact to clarify. So that's why I'm not giving you a hard time. I'm just asking you.
And, Your Honor, it's the state's understanding that this is what was argued at trial, and this was part of the jury instructions that were given to the jury when they made their decision. And kind of circling back, the question is whether it probably changed the trial. And the court never analyzed this underneath the accomplice liability. Nowhere in the court's ruling does it state, that, and go through an analysis of the accomplice liability. It appeared that the trial court, was unaware that, the state had argued during its closing accomplice liability. The state also...
Was it argued to the trial court? Did the state argue in the new trial motion, the state argued accomplice liability?
Yes. At the trial court during the reference hearing, the state did bring up the accomplice liability aspect of it, and it's argued in page 21 of the state's appellate briefing.
Well, again, I'm not asking whether you're arguing it to us. I'm asking if you argued that to the trial court.
I believe it was argued to the trial court. I was not the attorney that was handling that, but it's my understanding that that was part of the state's argument, was this accomplice liability. In looking over it, I understand that it wasn't necessarily a major focus, but the trial court did not go through an accomplice liability standard. And kind of veering into whether or not it's merely impeachment evidence. The court seems to conflate eyewitness testimony with impeachment, specifically in the court's ruling.
Counsel, I'll interrupt just to close the loop on that last issue. The cite on page 21 of your brief is to the 1996 clerk's papers, and I'm just letting you know those are not in the record. They're at 1996 CP 38 is your cite to that WIPIC. Now you've set out the WIPIC in the in its totality there as an offset paragraph, but those clerk's papers are not in the record. Just letting you know.
Okay.
How would you wish us to proceed with that in mind?
Well, based on the report of the proceedings, it was argued that there was an accomplice liability. So he was found guilty underneath. The jury was instructed on the accomplice liability standard. While those specific clerk papers are not part of the record, the report of the proceedings during the original trial are. And that was part of the state's argument. The judgment and sentence, all of that is part of the proceedings. So the state believes that because it's in the report of the proceedings, it's sufficient for appellate purposes to be able to argue this.
Doesn't that make it a bit difficult for the trial court to do an analysis then without knowing what they were supposed to be analyzing?
That would make it very difficult, Your Honor. And that's part of why the state believes that the court had based its reasoning on untenable grounds, because the trial court never went through an accomplice liability standard, which is what the jury was instructed on and what he was convicted of.
Is the trial court required on the record to go through every analysis?
I think that when you're making an analysis on that it would probably change the outcome of the trial, it's important to understand what the state had to prove at that trial. And the court, at a minimum, would need to go through and show how, underneath the accomplice liability standard, that it would probably change the outcome of the trial. Obviously, every little argument the trial court doesn't have to go through, but it is of utmost importance to get the fact, or to understand what the original trial actually was and what the state had to prove at that trial. And kind of moving on to it's merely impeachment. There's numerous witnesses that are saying that he went through and was grabbing weapons, that he was saying he hit him in the head with a 2x4, and the court seemed to inflate this eyewitness testimony aspect, and by basically saying since it's eyewitness testimony, it can't be impeachment. That's basically what the court was saying in its ruling, which is inconsistent. And there was also...
Well, it can be impeachment. The question is it merely impeaching, right? Is it only impeaching? And eyewitness testimony stands alone. You know, obviously, you can get certain evidence into the record because it's impeaching. But eyewitness testimony is directly admissible. You don't need to go through the impeachment exception, right?
And the state would point to the record where Josephine, during the original trial, stated that Mr. Foutch said that Henderson beat him over the head with a 2x4. Mr. Foutch's testimonial statement through Josephine came in during that original trial. So for him to say otherwise now would be merely impeachment.
Thank you, Mr. LaVorte.
Thank you.
Good morning. I'm Jody Backlund, here on behalf of Mr. Henderson, who is present in court today. The trial court in this case did exactly what we want trial courts to do. They listen to the evidence in a fair and neutral way, make a credibility determination, and then apply the law to the facts. That is exactly what happened here, and that was how Judge Fassett undertook her job. The state doesn't like the outcome, but that doesn't mean that the trial court committed any error. In fact, it did not. In fact, reading the state's brief, it's clear they don't assign error to a single finding or conclusion of the court. There are no statements of issues or challenges to findings of fact. This court should affirm what the trial court did. Mr. Henderson has claimed his innocence since 1996. Finally, after 20 years, the Innocence Project took up his case. It turned out he was telling us the truth. Foutch did the murder. Foutch, after he'd been released from prison, completed successfully his probation, opted to come forward and confess to the case. He had made statements to the contrary before, and he explained those statements to the court. He explained himself what had happened, what his motivations were, and explained why he had not come forward sooner. He clarified why he didn't really like Mr. Henderson, and he still doesn't. He had nothing to gain from bringing himself to the attention of the state. Judge Fassett listened to him, having read the entire trial transcripts, understanding exactly the theories that were brought at trial, and made a finding. Now, I wasn't there. None of us were there. But Judge Fassett was there. Judge Fassett listened to Mr. Foutch and made a finding that he was reliable. She made detailed findings supporting her decision. As acknowledged by the state, the trial court has discretion to determine credibility. The court cannot abuse its discretion by finding someone credible. The standard of review here is abuse of discretion because trial courts are doing exactly what we want them to do when they make these kinds of decisions.
So as I'm gathering from the state's argument, their argument is even if everything Foutch says is true, Mr. Henderson still would have been convicted on an accomplice liability theory. So talk about that.
Sure, that's hard to understand. It's hard for me to set aside a person coming to court, looking at a jury and saying, I committed the murder, here's exactly how I did it, and here's how my life has gone since then. It's hard to imagine how a jury could ignore such testimony. I've never read a trial where that happened. I can't imagine a jury could set that aside. Judge Fassett's conclusion that having that happen at trial would make a big difference in the outcome makes total sense to me, and I think it should make sense to you. It's not that there was never any evidence to the contrary in the trial. There was some evidence that was different from what Mr. Foutch currently tells us happened, right? But that's not the standard. The state argues that they can find some evidence that still could point to accomplice liability. First of all, Accomplice liability was not the state's theory at trial. Second of all, they didn't ask the court to make any findings in this hearing, this reference hearing, about accomplice liability. They didn't assign any error when the court failed to make those findings. So I'd ask the court to not put too much importance at that, but in terms of the actual evidence at trial that we still know about, some of it was consistent with what Mr. Foutch now says, some of it wasn't. Some people were more believable than other people. Some people might have been motivated by what we've heard about, which is that Foutch made it clear the plan was, put Mr. Henderson in my role, blame everything on him. Mr. Henderson was an outsider to this group. This group had a lot of history, especially history with the victim, Mr. Robinette. So none of those pieces of evidence are stronger than a person sitting in front of the jury and swearing under oath that they committed a murder. But I guess I would say, even if they were, that's not for us. That's for the trial court. The trial court decided, having read the trial transcript, listened to the current witnesses, and thought through what has happened, including the evidence that was against Mr. Henderson, that would have changed the outcome. Foutch didn't testify in the first trial. If he testified at a murder trial, saying that he's not the one who did it, I am, it makes a lot of sense that a jury would be persuaded by that kind of evidence.
What about when he testifies that Mr. Henderson helped him push open the door or kick open the door? Isn't that going to implicate Mr. Henderson as an accomplice?
It theoretically could. Again, that is not what the trial judge found. And what you have to do is say she was not just wrong or did it differently than I would do, but that she abused her broad discretion. Now, trial courts have general broad discretion to determine credibility, but in the case of overturning or vacating a prior conviction, their discretion is even broader, because what judges want, I think, the cases tell me this is true, I don't mean to tell you what you want, but what judges want is finality. What the system wants is to confirm a final outcome. And so because of that, that kind of judge deserves an even more deferential review. So I don't think so. The state's theory wasn't accomplice liability. I guess if we go down the retrial road, they could have a different theory.
What do we make of the lack of a record on that, on the accomplice liability instruction? There's a cite to clerk's papers that are not in the record. I know I said earlier that makes it difficult for the trial court, but they, on this hearing, read the transcripts. They would know.
They did.
It really makes it hard for us, doesn't it?
Well, I've been an appeal attorney a long time, and I like to avoid the kinds of situations where you don't have what you need to rule in my favor. But sometimes when you don't, because you don't have what you need, that's my job, right, as the appellant, to give you all the information you need to rule in my favor. If the state doesn't give you all the information you need, I mean, first of all, I would say, I have those clerk's papers. I don't think that changes anything. I don't think any of the arguments were borne out by what's in there. But even if there's some secret magic in those clerk's papers, boy, it's not your job to go find it. It's the appellant's job. If the trial court didn't read it and take it into consideration, and the trial court here very clearly said, I read the trial transcript. Now that's a monster, that's a big reading, right? I read the trial transcript, that's what I considered. Well, she's not wrong to do what she's given, right? She's not abusing her discretion by reviewing all the materials that she's given.
And what about reliability? Each of the parties discusses reliability. We don't have a recantation here. Do
Nope.
we need to? I mean, it's extra what the court did, but is that important for us to analyze at all?
I don't know what technical difference it would make if you call it a recantation or not. The previous statements weren't under oath. He didn't testify in this trial. He pled guilty, I think, to something less than the principal, but I don't want to be quoted on that.
Right.
Please. I know I just said it on recording, so I kind of will be quoted, but I don't know what difference that makes to the analysis of trial judge sat in the courtroom, listened to the person, give an emotional confession to a murder, a lifetime ago probably to that person, believed that person. That evidence did not come up at the trial, believed that it would make a difference at the new trial. Wow, that makes a lot of sense, but even if you're not sure that it does, it's certainly not an abuse of discretion.
Well, isn't it fair to say that reliability sort of permeates criminal rules 7.5? I mean,
Sure.
whether something does or doesn't change, probably change the trial? It would be hard to make that determination on something that's not reliable, would it not?
Well, of course, I think the reliability determination makes sense. She looked at the person acknowledged all their record and past behavior, the person explained in a way that makes a lot of sense motivations for acting the way they acted in the past and motivation for acting the way they're acting in the present, gave a level of detail that was very persuasive and makes a lot of sense given what happened and what we know happened. All those things go into reliability. The only reason to find this person not reliable is because no people who've ever been convicted of a crime aren't reliable. And of course, that's not the position the court took. It's certainly not a position I would encourage you to take. People who've been on the other side of the criminal justice system have things to tell us about what they've been through, what they've seen, and what they've done. And this trial judge had good reason to find this one credible. And that is not something I think that this court should second guess.
How about impeachment? Is it, because it's contrary, does that necessarily mean it's impeaching?
Well, I mean, I guess part of it could be, right? I mean, obviously, I think showing up and saying I was there and here's what I did and here's what I saw other people do is not impeaching. There are pieces of Foutch's testimony that would impeach things other people said, assuming they keep a consistent story, which I think is a little up in the air, but what do I know? But simply saying, he has a lot more to offer than just what so-and-so told you is not correct. He has a lot more to offer in terms of he was the only person who was there who has ever raised their hand to testify, right? There were 3 people that got charged. One of them is my client. Mr. Foutch is the only person that was there who has said, I will tell you what happened. He is all that there is in terms of eyewitnesses. The other information is all circumstantial. I'm not saying that I think it's strong or weak. I don't think that really matters because we have substantive evidence that was believed by the trial court who read the entire trial transcript and said, yes, this would make a difference. It would probably change the outcome. I want to give another chance for questions. In terms of the I'll just say thank you. We urge the court to affirm the finding of the trial court. The trial court, as I said, did exactly what we want trial judges to do. Listen in a fair and neutral manner, make findings on fact, and apply them to the law. That was all done here. It was all appropriately taken care of. We urge the court to affirm. Thank you.
Thank you.
Thank you, Ms. Backlund.
I might have done it, but he deserved it. That is what Henderson told a law enforcement officer. So Mr. Foutch going and taking and saying it was all me is in direct contradiction to what Henderson told a law enforcement officer. It was also admitted that there was a conversation between Foutch and Henderson where Josephine heard Foutch say that Henderson beat him over the head with the 2x4. There was a statement that was testified to. James Fannin, he heard Henderson say, I smashed his head with a 2x4 while laughing. There was also a statement in the record. Charlotte Hoyt testified she heard Pyles say he wanted to kill Henderson when he was about 10 feet away. John Correll testified that he saw him with a black metal pipe. Josephine also heard Henderson say that he smashed his head with a 2x4. And when asked if he was involved, he said, yeah. So to think that this is probably, to rule this is probably going to change the outcome of a trial, that Mr. Foutch coming forward and saying that he did it and that Henderson wasn't involved, it's not what the record supports because Henderson was there. Henderson admitted it to multiple different people, and he also even implicitly admitted it to a law enforcement officer. Somebody doesn't go and tell a law enforcement officer, I might have done it when you're being booked into jail for potential, murder, and say, I might have done it, but he deserved it, while comparing himself to OJ. right?
So this isn't a sufficiency of the evidence case though, right? I mean, yes, there is certainly evidence in this record that could convict Mr. Henderson, but that isn't our task, right?
It's not. The question is whether it would probably change the outcome of the trial.
And the
Not-
trial court found that, and our review is abuse of discretion.
Yes.
So we have to say, basically, the trial court weighed all this evidence, heard from Mr. Foutch, considered, everything that was said at trial, and the trial court decided, yes, it would probably change the result. So how can we second guess the trial court?
I'd add, no other finder of fact, no reasonable finder of fact could have ruled like the trial court did, right?
And that's basically what the state's argument right here, is that.
So I'll be the third one to add in. So none of the quotes you just read have anything to do with accomplice liability, do they? I mean, each one of those quotes seem to me to be direct liability, and yet you're faulting the trial court for not doing an analysis of accomplice liability. How do those statements support the error you started with the trial court for not addressing accomplice liability?
And the jury was instructed on accomplice liability, and the court never went through that analysis. That's one way that they abused their discretion in finding that it would probably change the outcome. Also, there was overwhelming evidence in the record indicating that, Henderson was involved. He had admitted it. And those are both reasons that the trial court abused its discretion.
But you concede on that second point, the trial court did do that job at this hearing. You're just saying did it completely wrong.
Yeah, and we're saying that because it's not possibly, it's probably, right? Which is a higher standard than just saying, well, somebody's saying something different, so that would probably change, or possibly change the outcome. It's probably, which is higher than possibly, and with an admission by the defendant himself to say that somebody coming forward and taking blame is going to probably change the outcome is unreasonable. The court never went through the accomplice liability standard. We have admissions in the record. Henderson, said that he was laughing when asked if he was involved. He said, yeah. Numerous people placed them, talking with each other, beforehand, that there was a statement from Pyles with Henderson in the room that he wanted to kill Robinette, that he went over there, that he, forced the door open. There's just so much evidence in the record that demonstrates Henderson was involved. Henderson was an accomplice. He knew what was going on. He pried the door open, and he also admitted it to a law enforcement officer. So to find that one of the co-defendants, one of the co-conspirators, comes forward and says, it was me after serving a jail sentence, and where he can face no repercussions when there's an admission by the defendant himself to say that would probably change the outcome, the state's arguing that would be an abuse of discretion.
Following these arguments, the appellate court concluded the trial court did not abuse its discretion in granting the new trial based on this newly discovered evidence. The decision was affirmed. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for new arguments every week.